Good afternoon, everyone. We are going to start this session, and I would like to welcome Dr. Kavita Pandey, ma'am, to IIT Delhi. She has served as Chief Commissioner of Income Tax, and she retired this January. Also, I would like to mention that she has pursued her PhD from IIT Delhi itself, so she is an alumni as well. I would like to welcome, ma'am.
Welcome friends and students of IIT Delhi. I'm thankful actually to my alma mater because I have recently completed my PhD from IIT Delhi itself to give me an opportunity to share my experiences of my services in the light of Constitution of India. I can just candidly confide with you people that if here I am intact, one piece, with my all mental faculties on, it is because of the blessings bestowed by the Constitution of India, the safeguards, the safeties. So I just would like to know that most of you are students of IIT Delhi, or am I meeting some of the faculty members also and staff members also? Please raise hands if you.
I'm staff. I'm from staff.
Okay, mostly staff. Okay, students. You people are students. So, before getting into the other matters, I would just share with you some of the backgrounds which led to the institution, I should say the Constitution of India, not a document, but I feel that it's an institution of Constitution of India. So, you all are aware that we had movement for independence, and towards the second half of the fourth decade, that is after 1942, there were lot many events which probably culminated into the Independence of India Act. So the and the last few of the incidents which I would give as a background of the Constitution of India is that we had the Second World War, and in the Second World War lot many Indian soldiers had served, they had sacrificed their life, there was lot of payments to be made to them. The British Crown, it was quite devoid of financial capacity, financial funds were on the lower side. Inside our country, which they called British India. So inside British India, there was already a nationalist movement for independence. Then other than that, other than the nationalist movement for independence, later half of the fourth decade, that means around 1946 onwards, there was lot of communal trouble in the country. And this communal trouble also, the British government was finding it quite difficult to tackle. So there were factors like movement for independence, the Second World War, the movement about the communal riots, which were very difficult to between the two major communities of India, which was very difficult to tackle. So it culminated into the Independence of India Act 1947, and under the Independence of India Act 1947, we got our independence. Now I just want to ask that when we got our independence in 1947, so what was the issue? Why do we celebrate Republic Day on 26th of January since 1950? So this question, was it not a republic since 15th of August 1947? What was the status of India? Can anyone, has anyone applied thought over it? Can anyone answer to this question?
Dominion state.
Yes, very good. It was dominion status under
Under 1935 Act.
under Government of India Act 1935 and under the protection of the British Crown. The 1935 Act, Government of India Act 1935, it was under the seal of the British Crown. So, even though we got the dominion status, we got the independence, so it was actually not a republic. Whatever, even the independence which we got, that was under Independence of India Act, and that Independence of India Act was also under the seal of the British Crown. So, of course, there were provisions in the Independence of India Act that India will be constituting a constituent assembly which will frame its constitution. There was provision also that till then the constituent assembly had the power to repeal, save or enact in accordance with any of the provisions of 1935 Government of India Act. So, it was basically 1935 Government of India Act under which the constituent, even the constituent assembly was functioning and India was functioning till we got, India became a republic. Now, the second question, that if you have read the preamble of the constitution, and I will share with you that preamble at a little later stage of time. So, in that preamble it mentions that we enact, adopt and give to ourselves the constitution, and while giving on this day, that is 24th of November 1949. So, what is the difference when we have given to ourselves on 24th of November 1949? What is the significance of the date 26th January 1950? So, can anyone? Okay. So, you people must have seen the budget document, or you people must have seen many of the statutes, many of the laws, even the IIT, there is some statute for the formation of Indian Institute of Technologies. So, there is one date for enactment, that on this day this bill is passed into an act, and there is another day which is effective, coming into effect of that date. So, the date of enactment, the date of adoption was 26th November 1949 and coming into effect was 26th of January 1950. So, these are little backgrounds which we should know now about the Constituent Assembly. So, the Constituent Assembly was formed under section 8 of the Independence of India Act 1935, and actually the 1935 Act, if you all are aware that everyone was not, all Indians, all adults Indians, that is universal adult franchise which we now have, they were not eligible to vote. There were so many conditions, one of them was educational criteria, matriculate, the other one was some taxpayers, and there were various criteria because of. So, even though the Constitution of India, it is a representative of the people of India, but actually the Constituent Assembly, it did not represent the entire adult franchisee, adult population of India, and when the Constitution was adopted, enacted, then it became a republic and all the democratic principles were applied, that it was universal adult franchise. So, under this backdrop, I just want to show you this Constitution of India, and this is the miniature version of the original Constitution of India, which was drafted and framed and adopted. This miniature version actually it's this voluminous, and the size is also quite huge, and the parliament has formed a miniature version, but it has duplicated in totality. So what is the special feature of this constitution? The original one, it is preserved in Parliament library in a case filled with nitrogen, so that the original version is preserved. This original version, when the draft of the constitution was finalized and it was ready, it was calligraphed by none other than Raizada, and it was there was lot of artistic decorations done in the constitution, in the margins of the constitution you can see, and these decorations were done by none other than Nandalal Bose of Shantiniketan. So this was not only a document which has given us so many of fundamental rights, which has given us our status to stand here, stature to stand with dignity, it is also a piece of art, a decorative piece, an aesthetic, a significant cultural symbol. The motto of our constitution is Satyameva Jayate. You know that the decorative pieces, they also contain lot of philosophical things, like what has the symbols of Mohenjo-daro and Harappa, the Vedic relics and other things. So I think if we apply ourselves and attach ourselves to this constitution, this is available in Khadi, that of Connaught Place. We can have a copy, and we can really have a feeling of this Constitution of India. So shall we start with the brass tacks? So background we have already discussed. About the Constituent Assembly we have already discussed. Date of enactment and adoption we have discussed. Now sources of the Constitution of India. So the Constitution, when the framers of the Constitution, and you know that we were very fortunate that at the time of drafting of the Constitution, people involved in the drafting of the Constitution, they were actually legal luminaries. And they had the whole shopping list of the constitutions, rights across the world, the old 200 years old US constitution, although the size of the US constitution was at that point of time just 6 articles were there, still few more articles have been added. Then there was the French constitution, the Irish constitution and Canadian constitution, and they could borrow, our framers of the constitution could borrow very special features, the outstanding features from the entire shopping list of the constitutions. And so these are the, during the course of our, when we move forward, we will discuss that what are the features which have been borrowed from different constitutions of different countries. The one outstanding feature of our constitution is that it is the largest constitution of the world, comprising of 395 articles, and probably this is because that all the nuances, even to the extent of the minute procedures also, they have been incorporated in our constitution, and this is probably because our constitution, a large chunk of it has been borrowed from the Government of India Act 1935. So first we would be going through taking a round of the features of our constitution. Before that we would be reading the preamble, and after that we would be going to outstanding features of our constitution, and then we would go to how these outstanding features have led to bliss. Bliss for the citizens of India, bliss for members of our society, bliss for the civil servants, bliss for students, any individual, dignity of the individual, how it has resulted into bliss. And finally, there is one very important aspect, that is doctrine of basic structure of constitution. So, we will just decipher, cull out that what ultimately is the basic structure of the constitution. We have, when we go through the preamble, we have a question now, that constitution, it has been authored by whom, it has been prepared by whom, who has constituted the constitution, constitution secured to whom, secured to all the citizens, what has been secured to all the citizens, and promote among the citizens what. So, we will split our constitution's preamble into 4 parts, and that will give us some clue. So, we will first go through the preamble, and this preamble I have just copied from this one and added few words which have been inserted by way of subsequent amendment. So, this is the original preamble in the original constitutional document. But before that, I'll just read out an ancient hymn from our scriptures, and then I'll read the constitution, and then why that puzzle I'll put at a later stage. So, there is an ancient hymn, and I think all of you are aware of that. Most of you must be knowing, because it is the motto of many of our institutions and organizations. Sarve bhavantu sukhina, sarve santu niramaya, sarve bhadrani pashyantu, ma kaschit dukh bhag bhavet. So, everyone should be happy, everyone should be healthy, everyone should have a good attitude towards other, and nobody should be unhappy, nobody should be at pain. So, this is the prayer, this is the prayer. And now I read the constitution's preamble, and I would like all of you to devote utmost attention to each word which I would be reading, because each of the word, each of the terms has a significance. So, shall we continue to proceed? Does it? Yeah. I think even if this is not functional, am I audible to everyone there? Yes, ma'am. So, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. But let's wait here, pause here. So, we the people of India, having solemnly resolved to constitute India. So, this is the constitution. We constitute India. What we do? We constitute India, and that is the constitution. So, what we constitute India into? Into a sovereign republic, into a socialist republic, into a secular republic, and into a democratic republic. The terms socialist and secular have been added by 42nd Constitution Amendment, 42nd Constitution Amendment Act, 1976. So, now you have understood that what is the constitution of India. So, that is sovereign, socialist, secular, democratic republic. Now, sovereign, and it is we. So, the people of India have sovereign power. They are the sovereign framers of the constitution, and they have sovereign power in the Republic of India. That is why it is called sovereign. Then we have socialist. When we look at our constitution, when we get into chapter 3, part 3 of our constitution, that is the part pertaining to fundamental rights, part 4 of our constitution, the part 4 pertaining to the directive principles of state policy. Actually, these are nothing but embodiment of the socialistic principles. And because of that, we are socialist republic. We constitute India into a socialist republic. Then secular. And you would see many of the articles of the fundamental rights and many of the articles of the constitution itself which promotes secular values, secular ethos. So we are a secular republic, and then we are a democratic republic. Why democratic and how democratic republic? Democratic republic because by stroke of a pen we gave ourselves power for universal adult franchise. This is democracy, that now we select our government, we the people select our government, and that is why it is a democratic republic. So now the question arises, when we have a term democratic, why we use republic also? Republics are mostly democratic, right? Actually, if you get into our history, we had so many janpadas in ancient time, and those were also republics. Those republics were the small kingdoms, they united into one, and then they became a republic. So they were republics, but in actual sense they were not democratic republic. So what India is constituted into is a democratic republic, and also democracy is a form of government, like monarchy is a form of government. So republic is to democracy as monarchy, as kingdom is to monarchy, or sorry, as monarchy is to kingdom. So this is why we have repeated the term democratic and republic. So this is the constitution. Now what we add to this republic? Now we add to this republic secure to all its citizens. So we give the security to all the citizens, and giving the security means actually ensuring three aspects. One aspect is justice, the other aspect is the aspect of liberty, the other aspect is aspect of fraternity. If you all remember the famous trio of French Revolution, these are liberty, justice, equality, fraternity. So what kind of justice we are giving to ourselves, to our citizens? Social, economic and political. So political justice we made in the day we adopted an effective date of our constitution, it became a democratic republic because a universal adult franchise became the law of the land. Now social, we have so many fundamental rights, directive principles which ensure social justice. Now economic. So economic justice is in two ways. We know that there were principles laid down by Adam Smith of equity, fairness. Those are the economic principles. So economic justice for those who are into trade, profession, business, or any other activity of like nature, economic justice to them also. Then economic justice to the real downtrodden people who really need to be developed, who really need some economic support. So economic justice for them. So this is the meaning of justice. Now we come to equality. So we have equality, two kinds of equality. One is equality of status and the other one is equality of opportunity. So we here in IIT, I think no other place can better explain the ethos of equality of opportunity. You people have availed of the opportunity which our constitution and subsequent statutory provisions, they have ensured. So equality of opportunity from all segments, and fortunately, it's very fortunate that the students coming to IIT, they are representations of all segments, all sections, all classes of society, and this is the best example of the fruitful result of equality of opportunity. Then equality of status. So equality of status means if there is a person who is from one class, the other person is from a different class, So in the eyes of law, the two entities, two persons will hold the same status. So this is equality of status. So this is the way we distinguish between the two kinds of equalities enshrined in our preamble of the Constitution. Then this is, we got justice, we forgot about liberty. So what kind of liberty? Liberty of thought, expression, belief, faith and worship. Each word, I think all of us are intelligent enough to understand, and I would not further elaborate it. So three principles have been secured to the people of India: justice, liberty, equality. And now the fourth one, the Constitution has not said that we want to secure this. They only say that we promote. So day by day it is being promoted, and we have reached a stage. And what is that promotion? Fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Again the term integrity has been added by way of subsequent amendment, and now you see that how fraternity leads to unity and integrity of the nation. If there is a fight, it's a disintegration. If there is a fraternity, the bonding, knowing each other, understanding each other, and what each other means, a person of South India knowing person from Northern India. India is a melting, India is a melting pot of all the races. So the principle, the ethos of fraternity has all throughout been in our philosophy, in our scripture, in our culture, that has only been enshrined in our law. So this is how fraternity promotes integrity and unity of the nation. Now my question, I had just shared with you that hymn which is the prayer for wellness, well-being of everyone. So how this preamble is different from that prayer? Can anyone share his thought on it? हाँ, बहुत सही। ऐसा है बेटा कि वो जो श्लोक था वो एक प्रेयर है। वो प्रेयर वो है जो हम ईश्वर से प्रार्थना करते हैं और अपने अंदर से इसको इनकलकेट करने के लिए कि हम क्या कर सकते हैं सर्वे भवन्तु सुखिनः के लिए, सर्वे सन्तु निरामयाः के लिए, व्हाट वी कैन डू। लेकिन ये जो है, ये कॉन्स्टिट्यूशन का जो सिमिलर वैल्यूज हैं, एसेंस दोनों का सिमिलर है, लेकिन इट हैज अ गारंटी ऑफ लॉ. It has the guarantee of the Constitution of India. It is to be ensured by our government. It is to be ensured by our country. So, in this way, the prayer is different from the constitutional guarantee. Now, one thing I would share with you, if anyone has written, if any of the PhD students was here, or any research paper, then you would see that in all the research papers there will be a small write-up, and that is called abstract. In the PhD thesis, the first few pages are the abstract of that thesis. So when do you write that abstract? While writing the research paper? Before you write the research paper? Before you write your thesis? No. Sorry? Yes.
When we get the essence of that thing, then we write the abstracts.
Very good. Excellent. So this is what in Constitution it has been done, that once the Constitution was completely drafted and the draft was almost accepted, then the preamble was written. And that is why the entire essence of the Constitution was captured in this preamble. And so whenever we go and search that what is the essence of our constitution, we have to refer time and again to our preamble. And in fact, when we move further forward, we will find that the judges, the courts, while interpreting the constitutional provisions, also they have referred time and again to the preamble. So I think we have almost gone through all the principles in this slide. Only thing I want to tell you that our constitution, the last main bullet, people of India. So there is a very great deal of accountability enshrined in the constitution itself. And that accountability, you can call it as checks and balances. And these checks and balances, they are meant for everyone, every person, every entity, every organization, every institution over which this constitution is applicable. Now you see that we have people of India. So people of India, they are sovereign. They exercise their sovereign power, they exercise their power over the legislatures, because legislators, they select the legislature, and the moment the legislature, they do not fulfill the aspirations of the people, they are thrown back. So the legislature is accountable to the people of India. So accountability is there. Then legislature is also accountable to the judiciary, which we will understand later. Now judiciary, we often hear about independence of judiciary. Judiciary is not thrown away by the people of India also. So how judiciary, how it is accountable? Anyone? So judiciary, you all know that there is a process of removal of Supreme Court judges, that is by way of impeachment. So the power to remove the judges, the accountability of the judges vests in the hands of the legislature, and the accountability of the legislator vests in the hands of the people. Now you tell me that how are people accountable? People are free, they are free citizens. We have just read that they have their equality, they have dignity, they have all liberty. So they are all independent. How are they accountable? Anyone? Sorry?
Fundamental duties. Fundamental duties we need to what for?
Fundamental duties, does it make us accountable?
And by acts and regulations.
So, sorry?
By the acts and regulations passed by the parliament, the rules enacted by the
Yes, that is the right answer. So what you talked about fundamental duties, it's right that it makes us responsible. But then there was something else also, someone had said another aspect. Directive principles. So directive principles is not directed at the people. Directive principle is directed at authorities. It is how the government's policies are to be framed. So the term itself, this chapter 4, it directive principles of state policy. State, how they frame their policy, they give these directive principles give a direction. So people's accountability, you have rightly said that it is by way of various statutory provisions. Various statutory provisions, the acts which legislatures are making, and the executive will implement those legislative statutes which have been framed. So everyone out here is having the checks and balances, and that is the beauty of the Constitution of India. So far anything else? Any question? Now we have already shared slides about now functioning of the state, constitution and functioning of the state. So it is most prolific constitution, it has 395 articles and 22 parts. we have, we already know that Constitution of India, the laws are made. Constitution is the mother of all the statutes, all the laws of India. Of course, there were many statutory provisions, many laws which were under the Government of India Act, and the Government of India, because of the Government of India Act, these laws were not immediately discontinued even after we adopted our Constitution. But there was a saving clause in our Constitution. So, through that saving clause, those acts, those statutory provisions also became the statutory provisions under the Constitution of India. It provides procedures, powers and functions of constitutional machineries under varied situations. It expands the power under one situation. In another situation, it restricts the power. So, it has ideal of exhaustiveness. Almost every situation, it has provided some clause, some article, and not necessarily that can be deciphered from one particular article. If there is a constitutional amendment article, Article 368, under what situation constitutional amendment will not be made, we go back to Article 13, then we go back to Article 32, we go back to Article even 23. There are because of this, we can find out that our Constitution is an exhaustive Constitution. Constitution embodies detailed provisions in respect of executive, legislature, judiciary, services, public service commission, election, vigilance, accountability and many other aspects. Now about the organization of the Constitution. So, this I am introducing you to the Constitution because we would understand first a bird's eye view of the Constitution, and understanding is very important. So, our Constitution has 22 parts and it has 12 schedules. Actually, when the Constitution was framed, at that time there were only 8 schedules, and you would see the signature at the end of this document. That will be interesting to go through that how the signature has been put at the end of this is 8th schedule. It is written 8th schedule, and below that 8th schedule the signature has started, and signature has started with Dr. Rajendra Prasad's signature first, and then Jawaharlal Nehru and all other members of the Constituent Assembly, and here somewhere here there is signature of B.R. Ambedkar. So, you can have a look at it if you want. So, we were talking that we had 8 schedules, and by way of constitutional amendment 4 more schedules have been added, and now we have 12 schedules. So, Constitution's part 1 deals with the Union and its territories, and that is Article 1 to 4 of the Constitution, and part 2 describes citizenship, that is the rights, the duties, not duties, rights of the constitutions, how under what circumstances a person is a citizen of India. Then part 3 pertains to fundamental rights, and that I consider as the conscience of the Constitution, and that is the single most part which is the most important in this Constitution in my opinion. Then we have part 4, which is directive principles of state policy. We had discussed. Part 4A is fundamental duties. We have certain duties, but these duties are in the nature of responsibility, in the nature of our contribution to our country, but they are actually not, we are actually not accountable in strict sense through these fundamental duties. Then we have part 5, that is about union. So, that is Article 52 to 151, and union means union has 3 organs. One is executive, the other one is legislature, and the third one is judiciary. Then of equal length is part 6, that is states. It starts from article 152 and ends at article 237. Part 7 has been repealed. Part 8 pertains to the union territories. Part 9 is the panchayats, deals with panchayats. Then part 9A is the municipalities. Then part 10 of the constitution, the scheduled and tribal areas, there are special provisions for these areas because these areas were very underdeveloped, and because of the special attention going to the principle of social justice, these areas have been provided special attention. Part 11 pertains to relation between union and the states, and this part is a very important part enshrining our federal principles. Principles of federalism is quite elaborately and quite lucidly depicted in this part. Part 12 is the finance, property, contracts and suits. The starting section of part 12 is starting article of part 12 is article 264, and that is quite that was the article which, when I went into civil services as a probationer, that article was introduced to us, that no taxes will be levied except under authority of law. So we cannot have kind of taxes which are prevalent, still prevalent to some extent in the society. They are those taxes by elements which are not favorable to congeniality of the society. So taxes which are the taxes levied by the government, that will be always under the authority of law. This is what we had been taught, and this is with these principles we served our entire career. So, finance, property, contracts and suits. Then part 13 pertains to trade, commerce and intercourse within the territory of India. Part 14, services under the union and the states. Part 14A, tribunals. Part 15 is a very important part, and that pertains to elections. And we would see that how this, for free and fair elections, the independence of the election commission in terms of its appointments, in terms of its functioning is important. Part 16, special provisions relating to certain classes. Part 17, official language. Part 18, emergency. Again, it's under emergency provisions. There is lot of change in the powers, in the balance between the center and powers of the center and the state, and lot of powers go off the states, they go to the center, and that is why we say that when there is an emergency, the country almost acts as a unitary entity. Then part 19 is miscellaneous, and part 20 is a single article part. This is article 368, that is amendments, constitutional, that pertains to constitutional amendments, and this has given rise the whole plethora of jurisprudence. So this is what is the part 21 and 22 are the transition provisions and repealing provisions. So this is, and then we have many schedules. The schedules are here. I would skip those slides except the 7th schedule, and of course I'll draw your attention to 9th schedule. Just have a look at the 9th schedule also, because subsequently when we would be discussing constitutional amendments and the basic structure, the 9th schedule will be important. 7th schedule is the schedule in which the powers to legislate has been included. We have the legislative powers of the center, that is in union list, the legislative powers of the state, that is in state list, and there are certain issues over which the legislative powers vest with both union and the states, and that is called Yes. So now legislative powers stipulated in the constitution, article 245, that gives parliament has been given law making power for whole or any part of the territory of India as per the provisions of the union list and as per the provisions of the concurrent list, and also under the situation of emergency many of the aspects of state list it can do. Under certain other situations also many of the aspects of the state lists can be legislated by the union legislature. Then legislature of the state vested with powers to make laws for the whole or part of the state. We have article 246 which provides for these three lists, and I have given some list of the statutory provisions which are incorporated in the union list, which are incorporated in the state list, and which are incorporated in the concurrent list. So obviously as the term goes, the issues which are of importance to the entire country or which are of importance to relation between states, which are of importance of relationship between states and the union, those will be done by the union legislature. So those are the issues which are incorporated in the union list. So income tax, and these are called entry number. So entry 82 and 85 of the union list. 82 is income, personal income, and 85 is corporate income. Then defense, naval, military and air forces, deployment of armed forces, these are entry 1 to 2A of the union list because they are very important. National highways etc., they are included in the union list. Currency coinage included in the union list. Foreign loans, entry 37 of the union list. RBI, that is also part of union list. Trade and commerce with foreign countries, interstate trade and commerce, they are part of union list. Then patents, inventions and designs are also part of union list. The issues which are to be attended to immediately by states, like public order, police, prisons, they are to be, they know how, what is happening in there, this region, how the regional forces are working. So they are incorporated in the state list, public order, police, prisons, local government, public health and sanitation, intoxicating liquors, agriculture. So there has been lot of debate that whether agriculture should also be, agricultural income should also be included in the union list, but this has remained a matter of state list, and actually agricultural activities of different states are different in, so if the legislation for promotion of agriculture, for application of various facets of agriculture is contained in the state list, then this will be good in my opinion. Then concurrent list, you know that the penal, like for one kind of offence, if all the states were given that procedure, criminal procedure, the punishments for various offences, punishments for civil offences, punishment for the procedure for civil disputes, if these are, if all the states are given independent powers, there will be different law for different states, and because we have fundamental rights that it is for unity and integrity of the country, people moving from one state to the other state, people residing in one state and the other state, people giving their taxes on income. Today I have given tax in Hyderabad, tomorrow I will be giving tax in Delhi. So these to keep a uniformity, there are various issues in the concurrent list, and in the matters of concurrent list, mostly the union has a supremacy, because if an enactment is done by a union on the matter of concurrent list and there is some kind of incoherence between a statute under the same entry, if a statute is made by the state, then to the extent of the repugnancy, to the extent of the difference, the union legislature will prevail. And education, of course, it is in concurrent list, because you know that right to education has become a fundamental right, and this statute was enacted by the center, and there are various states which are providing their education there under their statute, state statutes. They have various vernacular medium, they have various focal points for education. So education is rightly included in the concurrent list. Now the question arises that what are the features of our constitution which has secured bliss to our citizenry? And these, some of the features I have culled out, some of the from the constitution itself, some of the features I have culled out from the judicial pronouncements. And if you people have, because you people are children of sun, IITians I call them. So if you people have a look at the Constitution of India, you can find out certain other outstanding features which actually you will feel that it secures bliss to the citizens of India. And I'll read out these features and I'll ask you people if you can add some more features if you have gone through the Constitution. So the first one is the principle of democracy, the political freedom, that is universal adult franchise, then fundamental rights, and within the fundamental rights, you know that the jurisprudence evolution has been in such manner that there are large number of rights, and those are all fundamental in nature. They have evolved from one right, and that is right to life and personal liberty, taking within its fold several rights. Can anyone say that which is the article of the Constitution which entails right to life and personal liberty? 21. Yes, very good. It's Article 21. Then the other outstanding feature is equality in the eyes of law, equality of opportunity, federalism with unitary tilt. So we have discussed some of the features, and we would be discussing that our federalism has a unitary tilt, and this is for a particular reason. India is a large country in terms of various aspects. One aspect is in terms of its area. It's north, south, east, west. It's a vast country, I think 3,000 kilometers from north to south, and I think equal will be the distance from the Arunachal Pradesh to Rann of Kutch. I think it could be something of this. So you can understand that it's a vast country. So containing and administering a vast country is difficult, but allowing the federalism to work, allowing the independence for such vast country is all the more difficult. Then we had discussed earlier that India is a melting pot of races. So various cultures over a period of time temporally has come and it has melted into one. But sometimes what happens, you are students of science, that even if something melts, subsequent changes, subsequent temperature changes, they could again be bifurcated into different constituents, and the constituents will not be altogether the same. They will result into some harmful elements. So you have to, the integrity is very important, and for that integrity there has to be a unitary tilt, there has to be a central force which should direct the nation towards one integral part. So that is another reason. Then there are situations. India is a developing country. It has so many economic weaknesses, economic issues and other things. The states, if they start exercising various economic financial powers independently, the loan taking power, if they borrow from abroad, and if they exercise that unfettered right, then you can imagine that what will be the financial situation of India if some unruly element takes some unruly decision. So, you agree with me? So the unitarism amidst the federalism, that is the right decision which a visionary decision which our framers of constitution had taken. Independence of judiciary, that is I think, if we, after fundamental rights, if I am asked that what is the second best feature of the Constitution of India, in my opinion, it is independence of judiciary. And you would have seen, if you go through, if you are aware of the developments, recent developments or developments of the past, they have really served their best, contributed their best in protecting our fundamental rights, in promoting our directive principles, and in protecting the essence of the Constitution of India. Rigorous constitutional provisions for amending the Constitution. So, there are various situations under which the Constitution of India could be amended. So, there often a question is asked whether Constitution of India is a static document or a dynamic document. So, and we can justify it both ways. And if students of humanities or the aspirants of civil services, or for that matter, they are asked to write essays, and they are given, they can give justification both ways. And actually that is what is independence of human mind. Human mind, that is liberty of thought, expression. So our thought, we have liberty of thought, we have liberty of expression, we can justify it in different ways. So the constitutional amendments, we were talking about rigorous constitutional provisions, amendment provisions in the Constitution. So why it is rigorous? Because there are plurality of thoughts would be there. The society could be evolving, society could be dissenting, and if for each aspect, suppose a government gets a good majority, 50% majority, if a government gets in the parliament, then they can very frequently amend the constitutions. So there is rigorous check within the Article 368 itself, and even outside Article 368. When we would be getting into the details of Article 368, we would be telling. And there are provisions where, with a stroke of just a simple majority, how a simple statutory bill is passed, we can amend. We can, like even the boundaries of the state, we can just do by way of simple majority, that can be changed, and that is there in, I think, Article 4 of the Constitution when we talk about the union. So if there is consent between the two states, the boundaries can be expanded or constricted or split. Then we have Article 11 about the citizenship, that even the citizenship, the nature of persons, the qualifications for being a citizen can be changed, and that is not very difficult. The government has been given that power. But we go further. Then the provisions in Article 368. The provisions in Article 368, there are two kinds of, I think, two classes we could say, rather three classes of provision. The first class of provision is that where the Constitution can be amended, say by simple majority, and actually it is by way of simple majority, and then 2/3 of the voters, 2/3 of the legislators present and voting. So, this is simple majority means 50% majority in that house and the other house, and 2/3 present and voting, like I think if say 200 persons had registered for this this session, and if say 50 are here, so present and voting. So, that will be 2/3 of this 50, it will be I think some 32, 33. So, that will be the 2/3 majority, the number will be very less. So, by simple majority and 2/3 of present and voting, many of the constitutional provisions can be amended, and this is because it has been considered that the legislators, the people, representative of the people, they are in best know of the need of the people. They go to the people, they understand, they have been represented, they are representatives of the people, and they can, if majority of them feel that no, they would be needing this kind of provision, this right is to be curtailed and this kind of right is to be expanded. Why not? They get that power. But then there are certain provisions which would interfere with the functioning of the essential features of the government. Like there are some 5 situations under which it has been said 2/3 of the entire of both the houses, 2/3 of both the houses of parliament will be in a position, will be able to, first it is to be passed by 2/3 of both the houses, and then it is to be, then the bill is to be ratified by 50% of the state legislators. So, these provisions, naturally they would be difficult provisions, like election of the president. This is the president is considered to be a constitutional head of our country. So, for this we need a greater rigor. Powers of the executive, relationship between the center and the state, independence of judiciary. This is provided in the Article 368 itself by way of proviso. So, these are the issues when 2/3 of majority of the house, both the houses, assent of the president and ratification by at least 50% of the states will be required. So, this is the way the constitutional amendments take place. Our constitution in that manner is a dynamic constitution. You know, the society has changed over the period of time. The needs of society has changed. Cyber crimes have increased, and there are so many other things. The openness, the globalization, the economic globalization, the economic openness, they have after 1990 and 1991. These are the evolving features of our society, our country. So, the Constitution of India, in that way, it has been kept that it should not be a static one, it should keep evolving according to the need of our country. Any questions so far? So, no question means that either I am too good or I am so bad that nobody is able, I am not able to make myself legible to anyone. Checks and balances we have already discussed, and at the end basic structure of the constitution has to be unchangeable, not even by 2/3, not even by ratification by state. When it impacts any legislation, if it impacts basic structure of the constitution, it is unchangeable. So, we go to the fundamental rights first, and I will just enumerate all the fundamental rights, because it will be kind of, although it's like stating the obvious, but while enumerating we can keep discussing, so we can understand what we understand from our fundamental rights. So, the first article under the fundamental right is Article 12, And there is often a confusion that fundamental rights, it's a fundamental right. So I would just pick up your mobile and keep it in my pocket, and this is my fundamental right. That right to equality, or right to, of course, right to property I can't say, because it has been taken in Article 308, taken away from fundamental right. But then I can do anything and I can say fundamental rights, and I have a right against you, you have a right against me. But that is not correct. Fundamental right is right against the state, right against the government, right against the legislators, right against the authorities. So fundamental right is right against the authorities, not the right against the citizenry. There are rights against the citizenry, they are forming part of the statute. If there is dispute of property, you will go to property dispute tribunal, or you would go to court under the civil procedure code. If there is a criminal dispute, someone commits an criminal act over you, you would go to the police station and you will register your get your FIR registered. So those are the statutory provisions, but fundamental rights are rights only against the authorities, and that is given in Article 12 of our Constitution. Then we have Article 13, which is laws inconsistent with fundamental rights, they are going to be null and void. Otherwise, if we don't say, then there is no meaning of fundamental right, right? Then we have Article 14, which is equality before law, prohibition of discrimination on the grounds of religion, race, caste, sex or place of birth, Article 15. And here I would say that the day Constitution was enacted, immediately the Untouchability Prohibition Act, that was also enacted and adopted. So this kind of discrimination, which was 1,000 years old discrimination, by a stroke of pen, under the Constitution of India, under this, it was actually implemented. So this right is a very important right so far as our social system is concerned, where there are many various concerns arising on account of our social legacy, our I should not say cultural legacy, because we are not cultured if we follow to that extent, if we adhere to these menaces of caste system. But it was removed by a stroke of pen. Yes, socially we have been evolving, we have evolved, we are still in the process of evolving. That's a different thing, but that fundamental right was implemented by way of a statutory provision. Equality of opportunity in the matters of public employee, abolition of untouchability, Article 17, my apologies, this Article 17 has been specifically added for abolition of untouchability, and it is not forming part of Article 15, which is discrimination on account of religion, race, caste, sex. Specific article, and under this article that Untouchability Prohibition Act was passed. Then abolition of titles, Article 18. Earlier there were titles under the British, this thing, sir was there, and there were so many other titles which the British crown and government was giving to zamindars and to people of eminence. So that was abolished to give effect to the right to equality and the principles of social justice. Then we have protection of rights ensuring freedom. So this is a very important article, Article 19, and it entails freedom of speech and expression, freedom of peaceful assembly, right to form associations or unions, right to move freely throughout the territory of India, right to reside and settle in any part of territory of India. So I am sure you students must have given some kind of dharna in front of director's office, or the employees also would have gone for. So, and we never thought while exercising these rights that how you derive this right. Otherwise, who would allow you to stand there and just pronounce some slogans, or assemble and discuss in detail your thoughts about the functioning of the institute, functioning of the IIT. Okay. So my husband is indicating at the watch that I have to move forward. So this is right to protection of rights ensuring freedom. Then right of protection in respect of conviction of offences, that is also our fundamental right. And recent decision I would be discussing, and that recent discussion, decision, court decision, can you say that which decision of the Supreme Court, recent, just very recent decision of the Supreme Court, which has touched upon Article 20. This is Arvind Kejriwal's case. So I'll tell you at a subsequent. Then there are various plethora of rights, but right of protection against arrest and detention in certain cases, that is an important right, and that is why I have highlighted it. That is Article 22. Now we move to Article 21, because that is a very important article, and from that various judicial decisions have emanated, and that has given rise to several rights. And I would request the organizers to share these slides so that the students can go through at leisure, because we have a little time constraint. So Article 21 embodies a constitutional value of supreme importance in a democratic society, and this was the version of Justice P.N. Bhagwati. Article 21 is the procedural Magna Carta protective of life and liberty, and how life and liberty has been deciphered by different in different judicial pronouncements, that I will read in short, and few of them I would elaborate upon. So right to live with human dignity, that was in the case of Bandhua Mukti Morcha versus Union of India. And here when we talk about these rights, I would just share with you one of the largest contribution of Indian jurisprudence to the world jurisprudence is public interest litigations. And that by way of public interest litigation, the principles of public interest litigation also arises from constitutional interpretation, because we are a poor country. Majority of our people, they are deprived of the means to fight for justice before the court. So there are provisions of legal aid, and that will be, there are decisions that legal aid will be promoted. Now because of subsequent to those decisions, we have so many legal service authority, there are so many bar units are also given some kinds of responsibility to aid the people who are deprived of such opportunity, financially deprived or educationally deprived of such opportunity. So these are the results, these rights which has been interpreted under right to life and liberty, personal liberty. Many of them arise out of those public interest litigation. Although public interest litigation has been criticized because of locus, and locus standi is a concept, but that has really given rise to evolution of, it has walked in tandem with the evolution of our society. So right to live with human dignity was Bandhua Mukti Morcha case. Then we had right against sexual harassment at workplace, and this decision has been a landmark decision in terms of gender justice. The decision in the case of Vishakha versus State of Rajasthan, which had laid down many guiding principles. That what are the guiding principles for the authorities for weaker gender, at that time women. Now weaker gender has a very expansive interpretation in judicial decision of the Supreme Court, but at that time, and by way of that had travelled milestones. I have been chairperson of many of the gender guidelines made under Vishakha's committee, and the guidelines are so speaking, it empowers, it makes the weaker gender so their fear, their equality, the right to equality so pronounced because of this Supreme Court decision, and subsequently it has resulted into POSH Act, which is Prevention of Sexual Harassment at Workplace Act of 2013. So, this is right against sexual harassment at workplace. Right to reputation has been, you see that right to personal reputation, it has been held to be a right, fundamental right under Article 21, and it has been held that it is one of the important facet of right. Actually, when I joined service, I was told by people that your reputation travels faster than you. Before I join a particular place, Hyderabad or Baroda or anywhere, they said that your reputation has already travelled. So, reputation is so important, and I would beseech you people that please work upon your reputation. That is very important for your future life also. This has nothing to do with the constitutional lecture I am taking. Right to livelihood, right to shelter, right to social security and protection of family, right to health and medical care, right to get pollution free water and air. Actually, there were series of public interest litigations by one of the propounders of public interest litigations, MC Mehta. So, on various environmental issues, we got beautiful judgments by the Supreme Court and by way of public interest litigation. We get right to get pollution, free water and air, right to clean environment, right against passive smoking. This again is a very important right which has been held in Murli Deora's case. Right against noise pollution. Then right to know that what is happening, how our public funds are being utilized, how a particular organization, if the particular organization is a public limited company, the right to know in Indian Express's case has also been held to be a fundamental right. Right to personal liberty, Section 45 in the prevention of, here I would say about right to personal liberty, I would not detail further, but I would just give a small account of Arvind Kejriwal's case. So, Arvind Kejriwal was, you people all know that was arrested under the provisions of Prevention of Money Laundering Act. And this Prevention of Money Laundering Act, unlike the other acts like Indian Penal Code or Code of Criminal Procedure Code, presumption of innocence is the special feature, is a very important feature, basic feature, fundamental feature. But in this act, by way of Section 45 in Prevention of Money Laundering Act, I will just read the provision. Notwithstanding anything contained in the Code of Criminal Procedure, no person accused of an offence under this act shall be released on bail or on his own bond unless, now no person shall be released. So, this is that actually in the constitution also and Article 22 and in other acts also, no person will be detained except under authority of law, that is there, and there are so many, unless grounds of his detention are provided to him, he is given so many supports of legal aid, legal supports are provided, that is there. But here, unless the public prosecutor is given opportunity to oppose the application for such release, and where the public prosecutor opposes the application, it does not end here, opposes the application, the court is satisfied that there are reasonable grounds to believe that he is not guilty of such offence and that he is not likely to commit any offence while on bail. So, this is kind of the guarantee before the trial is over, the kind of guarantee, the prima facie guarantee the court has to give that he is not likely to cause any whatever, it is not likely to commit any offence, and reasonable ground that he is guilty of the offence. But the trial had not taken place and Mr. Arvind Kejriwal had been arrested and he had been detained for quite long time. So, the law is there, the constitutionality of this law, this has been challenged, and this will over a period of time we would know about the constitutionality of this law. But what happened that when the release order on bail of Mr. Arvind Kejriwal came, at that point of time the action taken by the CBI. So, that is something which had raised eyebrows, and the action taken by the CBI was the detention of Mr. Arvind Kejriwal. Against this, Mr. Arvind Kejriwal and I think even the Aam Aadmi Party, they moved the Supreme Court, and what a beautiful narration Justice Bhuiyan, I would just read. Denying bail or arresting someone just because they don't give the answers the investigating agencies are looking for is a potential violation of Article 23. And what 23 says? That every person has the fundamental right not to be compelled to give evidence against himself. Self-incrimination. The person cannot be compelled to self-incriminate. So, just because he is not giving a statement against himself, that cannot be the reason to detain him. You have evidences, you go ahead with your evidences, file evidences during the course of trial, and the decision will take place. So, 23 of the Constitution, what is the point of having arrived against self-incrimination if an accused can simply be kept in jail till she confesses to her crime? This would effectively punish someone without a clear finding of guilt. Such action on the part of the CBI raises a serious mark on the arrest itself. Power to arrest is one thing, but the need to arrest is altogether a different thing. It is important that the CBI dispels the notion of it being a caged parrot. So, this is what Justice Bhuiyan has pronounced. So, we can see that the independence, through independence of judiciary, the expression right to personal liberty, and also Article 20 where the right against right of self not to be compelled to provide self-incriminating evidence, that has been pronounced. Then right to privacy, that is a very, very important right, and recent time has seen. So, we write against telephone tapping, you are aware, right to have intimate relationship. So, I would just give a small brief about the evolution of right in respect of intimate relationship, and this is the LGBTI movement. So, LGBTI movement, that was altogether there, but that took a definitive turn by the decision of the Delhi High Court in case of Naz Foundation. When in the case of Naz Foundation, it was the right of LGBTI, this was upheld, and it was said that this is their right to life, right to have intimate relationship, right to decide about their gender, this is the right to life and right to personal liberty. Then this, unfortunately, this was U-turn took place by the Supreme Court in case of Suresh Kausal's case. And Suresh Kausal's case, it was said that no, it is for the legislature to decide that whether Article Section 377 of Indian Penal Code. By mistake, it has been written CRPC, so you people can read it as IPC. It is just a typographical error in this slide. So they turned that no, if it is to be decriminalized, if the sexual relationship among the same sex persons is to be consensual sex between the same sex person is to be decriminalized, it has to go to the legislatures and not the judiciary has no locus in this case. Then in Puttaswamy versus Union of India, again the judgment, there came a thumping judgment in favor of the right to privacy. And they mentioned, the Supreme Court mentioned, sex under Article 15 includes discrimination on the ground of gender identity and sexual orientation. That discrimination on the ground of sex would also include discrimination due to sexual orientation of sex stereotypes. There is a constitutional right to privacy inherent in the right to life, equality and fundamental freedoms. The right to privacy specifically includes the right to have intimate relations of one's choice and includes the right to sexual orientation and gender identity. Then came Navtej Jauhar's case, Supreme Court in 2018. And I think people from IIT, they must be aware of the Navtej Jauhar's case, because this was a determining point in Indian in acknowledging the rights of the intimate relationship, persons having intimate relationships within the same sex. In a 5-judge bench, unanimously the Supreme Court held that Section 377 of the IPC was unconstitutional to the extent that it criminalizes consensual relationship of any kind between adults and overruled its own decision in Kaushal's case. So you know that the constitutional, if there is a constitutional review, there is a section Article 145(3). So it says that at least 5 judges bench of the Supreme Court is empowered for constitutional review. So in Navtej Jauhar's case, this issue was, because it was review of the previous decision of the Supreme Court, 5 judges bench had decided upon the issue. So this is a great milestone in walking in tandem with the social evolution, because our society also gradually it has been accepting, the things are coming out in open, relationship between the same sex, and this social evolution has been accepted by the judiciary, by the supreme judiciary of our country, and this is a landmark, and it will also help in the social acknowledgement of the people having intimate relationship within the same sex. Then there are issues relating to like disclosure of dreadful diseases. In that case, the name has not been given, Mr. X versus Hospital Z. So in that case, a person was engaged and he did not inform his fiancée that he is suffering from HIV. The hospital and the doctors informed this fiancée, and the person sued the hospital and the doctor, and then the matter travelled to Supreme Court, and it was pronounced that fundamental right is not only for protecting your own fundamental right, but the fundamental right of the other person also with whom you are going to have relation, fiancé in your case. So this is what, then right to privacy and subjecting a person to medical tests, that in divorce cases, there are in many of the cases of divorce, there is an allegation, and this allegation should be based on evidences, of course, that is what the Supreme Court said, about the person not capable of having sexual relationship, and for this the matter travelled to Supreme Court that this is a privacy issue and one I cannot be compelled for medical examination, and the Supreme Court said no, based on cogent reason. If you are asked to undergo medical examination, that is the fundamental right of the other person, and that is not violative of your fundamental right. Then right against illegal detention we have discussed, right to free legal aid and right to appeal, that also we have discussed. Then federalism with unitary bias, we have discussed some of the articles. So Article 248 provides residuary power of legislation goes to the union. Article 249 says legislation by union in respect of matter in state list in national interest. 250 says legislation by union in matters of state list under proclamation of emergency. 251 and 254 in case of this we have already discussed actually. Now independence of judiciary, I will just say a little about collegium system. So you all know about NJAC Act, so National Judicial Appointment Commission. So the system, there was an act passed by the parliament, I think through 99th Constitutional Amendment Act, that the judges will be appointed through a commission, and that commission will comprise of the Prime Minister, other minister, then 2 persons of eminence appointed by the Prime Minister and leader of the opposition. So what happened, and it will be in consultation with the judges of the Supreme Court. So what happened, that this NJAC Act, it was challenged on the ground that if there are 2 persons from the cabinet, 2 persons of eminence appointed by the cabinet, so the decision will always tilt in favor of the ruling party, and the independence of it will be a great blow on independence of judiciary, and 99th Constitutional Amendment was struck down, and still collegium system is functioning, and the collegium system has been refined a lot by Supreme Court itself, that under the collegium system it is not that this the collegium of judges of the Supreme Court, they will decide that who is going to be the next judge of the Supreme Court. It is the collegium, the constitution of collegium is also to be done in a transparent manner. The Chief Justice will be consulted with 4 senior most judges of the Supreme Court. They will be 4 senior most judges, and their opinion will be recorded in writing, and it will not, and the judges, the new judge who will be inducted, for him the recommendation will be by consensus. So suppose even if 2 judges dissent, that will not be, the name will be deleted from the list recommended. So this is what we have travelled in respect of independence of judiciary. Then there are various other articles pertaining to the independence of judiciary, that is the rule of law. Article 141, that law declared by Supreme Court is to be binding on all the courts, civil and judicial authorities in the territory of India to act in aid of the Supreme Court, 144. So the Supreme Court decision is to be binding on us, or the jurisdictional high court decision is also binding on us. Minimum of 5-member bench of Supreme Court to have the last word on interpretation of constitution. Then judicial review of the act of the legislature, we had dealt at the beginning, Article 13, power of President to consult Supreme Court on matters of national importance, social importance. Citizens may approach jurisdictional high court to issue certain writs, and this is by way of Article 32. This is again a fundamental right, and there are 5 writs for which the citizen can approach the Supreme Court directly. And I wish I would have explained these 5 writs to you, but for paucity of time, I am not able to explain because I want to rush to the basic structure of the Constitution. Free and fair elections, again the bill, the Chief Election Commissioner and other election commissioners appointment conditions of service and terms of office bill was turned into act in December 2023, and that act again, it says many things about curbing the independence of the election commission. It has been challenged before the Supreme Court, and let's see that what the Supreme Court does while reviewing this legislation. We have watchdogs of legislature. How the legislative acts are, how the government is accountable to the legislature. So the legislature throws its watchdogs, and those watchdogs are the parliamentary committees. And one important parliamentary committee is Public Accounts Committee, and that is headed mostly by a senior member of the opposition, and they go through. There are standing committees, there are subject based committee, estimates committee, public account finance committees, and there are various committees of the parliament, and then they look very deeply into the issues of pertaining to legislation. They obtain opinion from the public, they invite opinion from trade bodies, and then they take into account everything before the bill is passed into the act. There are debates in the parliament, and the reports of these committees play a great role. I have incorporated about civil services, that independence of civil services. If we do not act independent as a civil servant within the framework of law, I think it is because of our own conscience problems. Otherwise, the Constitution has guaranteed no person who is a member of civil services of the Union or an All India services shall be dismissed or removed except under authority of law. Dismissal or removal or reduction in rank to be only after an inquiry in which the charge against the person have been informed to him and given a reasonable opportunity of being heard in respect of those charges. So we have constitutional protection and this is with the sole motive that we should exercise our duties without fear or favor. Then constitutional amendments we have already discussed. I wanted to discuss that we have cooperative fiscal federalism, where the Finance Commission, we have a Finance Commission, and Finance Commission will determine the norms by way of which there will be sharing of the proceeds of net proceeds of taxes. Net proceeds means after reduction of all the expenditure incurred, how it is to be shared with the states, and that has been incorporated in Article 280 is the constitution of the Finance Commission and related articles. If you go through the slides, I have given in detail how the GST, how it was the best example of cooperative fiscal federalism. The states gave up many of the powers to legislate, like State Sales Tax Act, Entry Tax. The center gave up curtailment of powers, legislation on excise, central excise duty, except some few items. And then there was a cooperative fiscal federalism, where GST at uniform rate across the country was implemented, and the procedure for the division of taxes was arrived at. A separate act was constituted for sharing, even that in the initial years if the states are going to have certain losses. So how the losses would be compensated, an act was constituted. Of course, that act was also challenged before the Supreme Court, that levy of cess for compensation to states, that is unconstitutional. But fortunately, it was upheld by the Supreme Court that no levy of cess for compensation to the state was justified, and it was not unconstitutional. So this is And that is why the cooperative fiscal federalism, we can just, this term has been coined. Outstanding features of the constitution, power to amend the basic structure. So there has been, because the time is already up, so there has been an evolution of jurisprudence on what is going to be the basic structure. So I will quickly run through, and you can run through these slides. So what happened? It started with the first constitutional amendment. And first constitutional amendment, because when India became independent, there was lot of enthusiasm. There was lot of enthusiasm for land reforms, agrarian reforms. The Jamindari system was there, and the governments, they wanted to abolish the Jamindari system, distribute the land ceiling acts. So these statutes were challenged in different high courts on the basis of fundamental rights, and many of the high courts, they upheld the new statute, because under Article 19 clause F, it was right to property was a fundamental right, and it was challenged. But because of the plethora of diverging decisions, this there was need for constitutional amendment. The government felt the need for constitutional amendment. Constitution's first amendment act was made, in which Article 31A, 31B was incorporated. 31A pertained to if any law for the purpose of agrarian reform is made, that will not be in derogation of the fundamental rights. Then 31B, what they did, that if any of the statute is included in the 9th schedule, and a new 9th schedule was made, 9th schedule, that law will be not challenged on the basis of the fact that it is in violation of the fundamental rights. Then people went to, the matter went to Supreme Court, and Supreme Court, in one of the cases, that was Shankari Prasad's case, Shankari Prasad, no legislature has power to amend the fundamental rights, and this was at that point of time. Subsequently in Sajjan Singh's case also, similar decision was given, but in that case there were dissenting decisions, and in those dissenting decisions, that certain aspects are not subject to challenge, but the term basic structure still did not come into picture. Then it came to Golaknath's case in 1967, and in that decision it reversed its original decision, and in that decision, that no, the legislators cannot amend the fundamental rights. So that was the decision. To revert this decision in Golaknath case, again the constitutional amendment was done, and then the matter travelled to the Supreme Court in case of Keshwanand Bharti case. And Keshwanand Bharti case, even though they upheld that Parliament has the power to make constitutional amendment, to amend fundamental rights, but it cannot amend if there is certain aspects of basic structure, and the term basic structure was coined for the first time in Keshwanand Bharti's case. Subsequently, few of the decision, that was Indira Gandhi's case, 39th I think it was, yes, it was 39th constitutional amendment. It was 1973, I think 1973 or no, 75. So in that case, again the law, what happened, that constitutional amendment was done, and it was said that they will not be questioned in any trial. Who will not be questioned? The Prime Minister will not be questioned, Speaker will not be questioned, President will not be questioned, and Vice President will not be questioned. And this, in Indira Gandhi's case, in this case it was held by the Supreme Court, no, this is the basic structure of the functioning of this will just jeopardize the functioning of the executive, that if these four powers of these four executives are not questioned. Then subsequently it came to constitutional amendment 42nd constitutional amendment of 1976, which was called mini constitution, and those many aspects of those mini constitution where Parliament gave enormous power to itself. They were just said that they were in violation of the basic structure of the constitution and they could not be upheld. So the constitutional amendment of 1976, that was many aspects were neutralized by the Supreme Court of India. So this was the then there are subsequent jurisprudence also which I have included in this slide because of the time. So what now the question is that what is the basic structure of the constitution? Is it an abstract thing which you will cull out from the constitution or as a whole, or is there any particular article pertaining to the basic structure? In fact, in Keshwanand Bharati's case itself, the two dissenting judges, one of them said that it's an abstract concept which has to be culled out from the constitution as a whole. The other one said that there has to be particular article for basic structure. So since there is no particular article, then he did not support the concept of the basic structure. But then the basic structure concept was upheld subsequently in Indira Gandhi's case, in Bhim Singh Ji's case, in Menaka Gandhi's case, and subsequently when this was reviewed in Minerva Mills' case, it was given a thumping upholding that the basic structure cannot be violated or demolished. So this is how it evolved. Now the basic structure, why I read the constitution, the preamble in detail, so that you people should understand the essence of the basic structure, and in addition to the essence of the principles of democracy, principles of secularism, principles of socialism, principles of liberty, principles of life, these are all basic structure of the form part of independence of judiciary, that is basic structure, federalism, quasi-federalism, these are all basic, static dynamism, because it's static, but under certain situation the constitution is dynamic. That is also the part of basic structure of the constitution. And sorry, because there is no time, so I thought that we would so the principles of sovereignty, unity and integrity, democracy, social and political justice, liberty, fraternity, these are all principles of basic structure. Equality of status and opportunity, dignity of the individual, Montesquieuan principle of separation of power and rule of law. Yes, this is very important. So Montesquieu was a 17th century philosopher, and he had written in his book Spirit of Law. So there were two principles which the state was to follow, and those are the principles separation of power and the rule of law. So separation of power between the executive, legislature and the judiciary, which we have discussed at the beginning. So those are the Montesquieuan principle, that is also comprising of the basic structure. And rule of law. Rule of law, we have already that the decision of Supreme Court will be binding, the decision on the authorities below, the decision of Supreme Court will be binding on all the judiciary below, and it has to be, the constitution is the Supreme, Supreme Court, at least 5-member bench is the supreme body for interpretation of constitution. That rule of law, this comprises of the basic structure of the constitution. Judicial review, power of judicial review, which we discussed in article 13, that is also the basic structure, and checks and balances, that is comprising of basic structure. And this quote of Plato, I would like one of the students to read, because if a student reads, I think this value I want all my IITian colleagues, friends, they should inculcate in themselves, because they are the future of the country. They are the ones who would be leading the country. Kindly read aloud, if, excuse me beta, can you please read this quote?
We can easily forgive a child who is afraid of the dark. The real tragedy of life is when men are afraid of the light.
Yes. So still, in spite of this Constitution of India guaranteeing so many things are happening in our country. We are moving in a positive direction, but then there are various drags, various retardations. So these retardations are by the people who are afraid of light, who don't want to see the light, and it is your role as leaders in the country, as potential leaders, to take the light to those people and you yourself not be afraid of light. Thank you so much. Thank you so much for your time and patience. We do not have any time for question session, but I thought that in between I had been asking if there was any opportunity. If you have any questions still, we can discuss it for 2-3 minutes. Yeah, please.
I have one question. Ma'am, you said that judiciary is accountable to people by executive power.
No, I didn't say that. I said judiciary is accountable to legislature through impeachment, because legislature has the power for impeachment. There are also laws made, regulations made for judiciary, and that power of impeachment is with the legislature, and legislature in turn is accountable to the people. So the legislature is bound that it will exercise impeachment power under right situation, and if the legislature does not do that, exercise that power, then people are there to whom the legislature is accountable. That was the check and balance. So thank you very much. All the best.